Imagine you have like this totally flawless legal argument. I mean, you have the facts on your side. You have the actual text of the law on your side.
Right.
You go into court, you present your case beautifully, and the judge completely agrees with you. You win.
Sounds great so far.
Yeah. But then, a few months later, the other side appeals the decision. So you go to a higher court. And the facts haven't changed at all. The wording of the law hasn't changed. But the new judge looks at the exact same case, and you lose completely. Just totally lose. Welcome to the deep dive.
Yeah, that scenario is, it's the harsh reality of the legal system. And it usually comes as a massive shock to anyone who expects the law to function like, a math equation.
Right, like a calculator.
Exactly. We tend to view the legal system as this giant calculator where you just input your problem, you hit a button, and the law outputs a single undeniable verdict.
But the law isn't made of rigid numbers. It's made of language.
Yeah.
It's made of human behavior, and, well, language is just notoriously murky.
Oh, absolutely.
I mean, if you move to a new country or start a business or get into any kind of dispute, you suddenly realize that the legal landscape it's less like a calculator and a lot more like a really old, really complex map where half the roads just aren't labeled.
Which is exactly why we are unpacking these really fascinating materials today from Kiril Stawrew.
Yes.
They're a Berlin-based law firm, and they specialize in advising expats, which is perfect because an expat is someone who is, by definition, dropped into totally unfamiliar legal territory.
Right, the language is different. The unwritten rules are
The whole system is foreign to them, so their materials are specifically designed to just demystify how the law and legal interpretation actually work for, people who aren't steeped in the system.
which is incredibly helpful for all of us. So we're going to build this from the ground up for you today. We'll start with the absolute foundation of how a law is supposed to function. Then we'll look at the actual mechanics of interpretation, like what actually happens when the rules don't clearly apply to real life.
Yeah, the messy stuff.
Yeah, exactly. And finally, we'll explore that opening scenario I mentioned. We'll look at why legal uncertainty is just a permanent feature of the system and how judges break ties when both sides have, perfectly valid arguments.
It's a great roadmap.
So let's start with the foundation, the difference between what lawyers call the normal case and the problem case.
Right. So to understand the normal case, the materials from Kiril Stawrew use this universally recognized analogy. The biblical commandment, honor thy father and mother.
Okay, yeah. On the surface, I mean, it's a very straightforward directive.
Right. It seems like a really simple rule. Do this specific action for these specific people.
Exactly.
And every law is essentially written with a specific idealized scenario in mind. That's the normal case. So the normal case for this commandment is a scenario where the law is incredibly easy to apply because reality perfectly matches what the lawmaker assumed. Imagine like a traditional family, biological parents who lovingly care for their child. They raise the child, they provide for all their needs, and create this perfectly harmonious environment.
In that specific scenario, applying the rule is totally frictionless.
Exactly. The child must honor the mother and father. The facts align perfectly with the text.
The equation actually works in that one specific instance. But, I mean, reality rarely stays inside those neat little boxes, right?
Rarely.
Human existence is so messy, and society is just constantly evolving in ways that the people who wrote those laws couldn't possibly have predicted.
And that friction between an old rule and a new reality is what creates what the law calls a problem case. It's a borderline case where the straightforward rule basically just hits a brick wall.
Okay, so think about how modern reality complicates honor thy father and mother. What happens when we introduce, say, adoption?
Right.
What about surrogacy?
Right.
Or, in vitro fertilization with egg and sperm donors?
Exactly. The moment you introduce adoption, the rule just kind of fractures.
Yeah.
Because you have to ask a really foundational question. Who legally qualifies as the father or mother that you are supposed to honor?
Do you honor the biological parents who gave you life but, perhaps gave you up?
Mm-hmm.
Do you honor the adoptive parents who raised you but actually share zero DNA with you?
Mm-hmm.
Or do you honor both? Or neither?
And it gets even messier because the complication goes even deeper than just identifying the people involved. There's also the ambiguity of the action itself, the actual word honor.
Yeah, that really stuck out to me, the source material. Like, what does that actually demand of a person?
Exactly.
If I just show up to family gatherings and remain polite, is that honoring? Or does it mean I'm, like, legally obligated to provide financial care for them in their old age?
Right. Or let's push it into the realm of conflict.
Okay.
What if you get into a severe argument with your parents and yell at them? Have you failed to honor them?
Oh.
What if the parents did something objectively terrible and your yelling was completely justified? Where is the exact line where normal family conflict legally crosses into, a failure to honor?
It really highlights this massive gap between the text on the page and the actual reality of human relationships.
It does. And bridging that gap is essentially the core task of the legal system. It's a process called concretization.
Concretization, making it concrete.
Exactly. The law is inherently abstract. Honor your parents is just an abstract concept. The entire machinery of the legal system, so lawyers, courts, judges, it all exists to take those abstract commandments and make them concrete for highly specific, very messy, real-world situations.
So when two lawyers are arguing in court, they aren't actually arguing about what the text of the law says. I mean, they both have the same book, right?
They do, yeah.
They're arguing about the concretization. They're debating whether a specific set of messy facts actually fits inside the abstract box the law created.
Precisely. They debate the concrete requirements. Did this specific person's specific action actually meet the legal threshold for honoring? And eventually, a judge has to draw a line in the sand and make a definitive call.
But, knowing the law is abstract doesn't really explain how a judge actually makes that call.
Right.
If the ancient rule doesn't have, like, a subclause explicitly detailing how to handle an adoption, how does the system figure out the answer? I mean, they can't just flip a coin.
No, they can't. And this is where we get into the art of legal interpretation. When a legal system faces a problem case, like adoption, the fundamental question the court has to ask is all about the degree of similarity.
Okay, similarity to what?
To the normal case. They have to decide, are the differences in this new messy case so profound that they require a completely different decision than the normal case? Or are the underlying dynamics similar enough that they should just be treated the same way?
Okay, but how do you measure that similarity?
Right.
It can't just be a visual comparison, right? Like an adoptive family might look exactly like a biological family, but the mechanics of how it came together are entirely different.
Right. So the measurement relies on a very specific logical process. You start by looking back at that baseline normal case, the harmonious biological family we talked about.
Got it.
Then you have to ask the golden question of legal interpretation. You ask, WHY, did the lawmaker create this rule for the normal case in the first place? What was their underlying purpose?
Ah, okay. So you are shifting from analyzing the text to analyzing the intent behind the text.
Exactly.
Let me try to work through the logic here using the Kiril Stawrew notes.
Go for it.
If we analyze honor thy father and mother, we could deduce a few different reasons for its existence. Let's assume, just for a moment, we decide the underlying WHY is the literal gift of life. The lawmaker wrote the rule because creating biological life is an act that inherently demands honor.
Okay, so if you follow that specific thread, how does it affect our problem case of adoption?
Well, if the rule exists purely to reward the biological gift of life, then in an adoption scenario, only the biological parents are entitled to that honor.
Right.
Because the adoptive parents didn't provide the biological life, so the underlying purpose of the rule doesn't apply to them. But UT, and here's where it gets interesting, if we change the WHY, the outcome flips entirely. What if we determine the lawmaker's true intent was to reward the immense personal sacrifice required to raise, feed, and educate a child?
That completely reorients the application of the rule.
Right, because if the WHY is about the sacrifice of raising a child, then the adoptive parents absolutely deserve the honor, and the biological parents who didn't raise the child might not deserve any honor at all.
Exactly. The exact same law produces two completely different verdicts depending entirely on how you define its underlying purpose.
Which is wild. So it all hinges on that WHY.
It does. That is the essence of building a legal argument. You have to define the why. But, a lawyer can't walk into court and simply announce their favorite interpretation of the lawmaker's intent.
Right. They can't just be like, I think they meant this.
Exactly. They have to prove it. And the primary tool for proving intent is the use of precedents.
Past decisions made by other courts.
Right. Precedents are basically historical markers showing how previous courts have interpreted that underlying purpose.
Okay.
The source material actually offers a brilliant example to illustrate this. Let's say you are the lawyer representing the adoptive parents.
Okay, I'm the lawyer.
And you want to prove that the WHY of the law is about raising the child, not biology. So You search the legal archives and you find a past ruling from the highest German court.
Mm-hmm.
In this specific past case, a child was raised entirely by their grandparents, and the highest court ruled that the child was legally obligated to honor those grandparents.
Wait, hold on. Let me think about this. I'm trying to see how that holds water in a courtroom. Grandparents aren't adoptive parents.
Right, they aren't.
They are biological relatives, yeah, but a totally different generation. If I am the opposing lawyer representing the biological parents, I would just stand up and say, Your Honor, that precedent is irrelevant. My clients are parents, not grandparents. That case just doesn't apply here.
And that's exactly what they would try to say.
So how does a lawyer actually use a mismatched precedent like that to win an adoption case?
Because you aren't using the precedent for its literal facts. You are using it to extract the underlying logic.
Oh.
As the lawyer for the adoptive parents, your argument is this. Did the grandparents give the child biological life? No. The child's parents did.
Right.
Yet the highest court still demanded the grandparents be honored. Why? The only logical conclusion is that the highest court previously determined that the quote-unquote gift of life is not the trigger for this law.
Okay, I see where this is going.
By ruling in favor of the grandparents, the highest court effectively declared that the act of raising the child is the true underlying purpose of the rule.
Oh, wow. That makes so much sense. So you basically force the court to acknowledge their own past logic.
Exactly.
You isolate the variable. By showing a case where biology was completely absent but honor was still demanded, you prove that biology isn't the deciding factor at all.
You nailed it.
And once you've established that raising the child is the true WHY, you simply point out that your clients, the adoptive parents, raised the child. Therefore, the rule applies to them.
You've bridged the gap. You used a problem case from the past to illuminate the underlying purpose, which then allows you to apply the abstract rule to your current problem case.
I mean, it feels like a very elegant piece of intellectual architecture.
It really is.
But we also know that if you put two lawyers in a room, they will absolutely find a way to argue about the architecture.
No, without a doubt.
So what happens when the precedents aren't that clean? Or when the word you are arguing about is so vague that it just defies a simple definition?
Well, that brings us to the reality of the gray area. Let's go back to the ambiguity of the word honor. Finding the why helps, but you still have to define the boundaries of the action itself. So how do courts handle that extreme subjectivity? They construct a spectrum based on all available precedents.
A spectrum. Like a spectrum of acceptable behavior.
A spectrum of legal interpretation. A court will look at historical rulings and identify the absolute extremes. On one end of the spectrum, they place actions that past courts have universally agreed clearly constitute honoring.
Like what?
Well, for example, providing full-time care for a bedridden parent. That is a definitive yes.
Right.
And on the far opposite end, they place actions that clearly violate the concept. Physical abuse, for instance. That is a definitive no.
Okay, so you anchor the two extremes so you actually have a frame of reference.
Exactly. Then the judge looks at the current problem case. Let's say it's the scenario we mentioned earlier, where the adult child yelled at their parents during a dispute over money. The judge takes that specific action and slides it along the spectrum, comparing it to all the precedents, trying to determine which extreme it sits closer to.
But, I mean, that slider is entirely subjective.
It is.
There is no mathematical formula that dictates a raised voice equals a, 40% violation of honor. A judge has to personally evaluate the context, the tone, the history of the relationship.
Which brings up a really critical point from the Kiril Stawrew materials regarding civil law.
Okay.
When you are dealing with disputes between private parties, like our expat who might be fighting a landlord or business partner, the court is often engaged in a massive balancing act.
The balancing act.
Yes. This concept fundamentally changes how you view a trial. In civil law, a judge isn't just a referee calling a foul. They are operating a scale. They are actively weighing mutual interests.
Okay, let me make sure I've got this. So let's say an expat signs a 2-year lease on an apartment in Berlin, but loses their visa after 6 months and literally has to leave the country.
Okay, good example.
They try to break the lease. The landlord sues for the remaining rent. Now, the law might say a contract can be broken for extraordinary hardship. The expat argues that being legally forced to leave the country is an extraordinary hardship. That's a highly logical argument with the law on its side.
It is, but the landlord has an equally logical argument. They relied on a signed legal contract to secure their financial livelihood. The actual text of the contract is completely on their side.
Right, so both sides have valid, legally sound arguments. Both sides can probably find precedents to support their position. So how does a judge break the tie?
By weighing who is more worthy of protection in that specific unique context.
Worthy of protection.
Exactly. The judge has to look at the severe financial impact on the landlord against the legal impossibility of the tenant remaining in the country. They weigh the broader societal interest in upholding the sanctity of contracts against the individual's lack of control over immigration policy.
Right.
It is an incredibly delicate, highly subjective balancing of competing rights.
And because it's subjective, the outcome is just never guaranteed.
Never.
Which perfectly explains that quote from the source material. 2 lawyers, 3 opinions.
Yes.
You can give the exact same set of facts to different legal professionals, and they will weigh those mutual interests completely differently.
Which loops us all the way back to the scenario you opened the deep dive with. The inherent subjectivity of the gray area means the appeals process can be an absolute roller coaster.
Oh,
You can go to a trial court, the first instance, and the judge might weigh the scale in favor of the expat tenant. They decide the visa issue is an extraordinary hardship that supersedes the contract. You win.
but then the landlord appeals.
Right. You move to a higher court,
Right.
the second instance. You present the exact same facts, the exact same contract, the exact same arguments about extraordinary hardship. But this new panel of judges weighs the societal interest in enforcing contracts more heavily than the first judge did.
They slide the case to a different spot on the spectrum.
Exactly. And suddenly, you lose.
I mean, if the system is that fluid, and if a perfectly argued case can be overturned simply because a different judge has a slightly different philosophy on balancing mutual interests, it makes going to court sound absolutely terrifying.
It really can be.
Isn't that a massive gamble? Like, why would any business or individual voluntarily subject themselves to that level of unpredictability?
Well, the reality is it is a gamble. Whenever a case exists in the gray area, and frankly, almost all cases that actually go to court exist in the gray area, otherwise they would have been resolved immediately, there is what the legal profession calls legal uncertainty.
Right.
But the crucial mechanism that keeps the entire system from just collapsing is the realization that this uncertainty is a shared risk.
It's a two-way street.
Exactly.
It's because the landlord might appeal and win, but they also carry the immense risk that the higher court will just agree with the first judge, and now the landlord is out even more money for legal fees.
Yes. Both parties are staring down the barrel of a judge's subjectivity. Neither side can be 100% confident that the court will adopt their interpretation of the why or balance the mutual interests in their favor.
Right.
And that shared fear of a total loss is actually the primary driver of legal resolution.
It forces a compromise.
It really does. The vast majority of legal disputes never end in a final dramatic verdict from a judge. They end in a settlement. This can happen before a lawsuit is even filed, or it can happen literally on the steps of the courthouse.
So I guess the goal of hiring a lawyer isn't necessarily to go into a courtroom and totally destroy the other side.
Not at all.
A huge part of their job is helping you calculate the odds of that legal uncertainty.
Precisely. They evaluate that spectrum of precedents, they assess how a judge might weigh your mutual interests against the opponents, and then they negotiate a settlement that mitigates your risk of losing everything.
So in a successful settlement, neither party walks away with everything they originally demanded.
Right. But neither party walks away empty-handed either. A settlement is the legal system's pragmatic mechanism for resolving disputes when finding an absolute objective truth is just impossible.
It's a feature of the gray area, not a bug.
Exactly.
It really reframes the whole concept of justice for me. It's less about finding the perfect mathematical answer and more about managing human conflict in a way that allows society to just keep functioning.
I think that's a perfect way to put it.
Well, we've covered a lot of ground today. We started by dismantling the idea of the law as a calculator, looking at how the normal case breaks down when faced with the messy realities of modern problem cases. We explored how lawyers bridge that gap by searching for the underlying purpose, the why of a law, and how they extract that logic from historical precedents.
Right.
And finally, we looked at the reality of the courtroom, where judges must subjectively weigh competing mutual interests, which creates this shared legal uncertainty that ultimately drives most disputes toward compromise.
Yeah, I mean, the legal system is fundamentally a human institution trying to manage the chaos of human behavior.
Beautifully said.
And as we finish up, I'll offer a final thought for you to take with you, building on this tension between old rules and new realities. The law is really always playing catch-up.
Yeah.
So the next time you see a news headline about a controversial Supreme Court ruling, or a strange legal verdict, resist the urge to just look at the literal text of the law. Look deeper. Ask yourself, what was the specific normal case the lawmaker envisioned when they wrote this rule 50 or 100 years ago? And how drastically has our current society shifted away from that assumption?
That is a fascinating way to look at it. The friction isn't usually about the words on the page. It's about the gap between the world the law was built for and the world we actually live in today.
Exactly.
Well, thank you for joining us on this exploration of the mechanics of the law. We hope this deep dive into Kiril Stavrew's insights has given you a much clearer map for navigating all the legal complexities out there. Until next time, keep asking why. Take care.